go from there.
Thank you.
The case is now being live streamed. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning. Welcome to this sitting of the single justice session of the Massachusetts Appeals Court. My name is Gabrielle Wolohojian. We're going to be hearing right now case number 2022 J0254, Commonwealth versus Walter Garcia Laboy. And Attorney Damota, we're ready when, or I'm ready whenever you are.
Yes, thank you, Judge. Judge, it's unconstitutional for Mr. Garcia Laboy to be held without bail pre-trial on for a nonviolent regulatory crime that he is presumed to have not committed. The statute, the 58A statute and the Bail Reform Act is an attempt to put into legislature the definition or defining of violent or dangerous crimes that someone could be held without bail. And that concept is something that is not something that Massachusetts legislature gets to decide what is and is not violent. That's something that is just a concept that has been understood to be something that includes the menace of dangerousness as the court outlines in Mendoza.
And is that attached to the person or is that attached to the crime? In other words, is the judge's task below to determine whether the person is dangerous?
I think that the way my understanding of the case law is that the court it's not so much as the person, so much as the likelihood for someone to commit a dangerous crime in the future. So I think
okay, but that's attached to the person, right? Yeah. That's an assessment about a specific defendant.
Right, and I think that's
okay. So that's going to help me. I'm going to ask you a hypothetical. In your view, could a person have committed or be charged with one of the predicate offenses and then nonetheless found not to be dangerous?
My understanding is that is a possibility with the court's second step analysis, right?
Okay, so it's not simply whether or not the person has been, the dangerousness analysis for purposes of Section 58A is not simply an assessment of whether the person has been charged with one of the predicate offenses, correct?
Right.
All right. So I'm glad we have that understanding because that helps me. So is it possible, again, hypothetically, set aside this case, for a person to be charged with the types of offenses this defendant was, the drug trafficking charges, and be found to be dangerous?
Under the current statutory scheme, yes. I mean, absolutely.
Okay, absolutely. But you're saying what? Are you saying that that should never be allowed to happen because inherently the drug trafficking charge is not dangerous? Or are you arguing that in the circumstances of this case, where there was nothing more than simply 3 controlled buys, the judge couldn't, even accepting that this was a predicate offense for the statute, the judge should not have found your client dangerous?
It's the former. If
it's the first. Okay.
That drug trafficking, this charge should never be something that should be permitted to be held without bail.
Okay, and what's my standard of review for that?
The court's review for that would be, I believe, abuse of discretion, if I'm remembering that correctly.
Okay, so if I am reviewing, play that out for me a little bit if you don't mind. I am reviewing to see if the judge abused, and I don't remember who the judge is, I'm just going to call him his.
Judge Dressler, yeah.
that the judge abused his discretion in accepting the statutory scheme that the particular drug charges here were predicate offenses.
Right.
Okay. And so with that in mind, what exactly is your argument about due process? Who violated due process and how?
The court violated my client's due process rights when he was detained without bail on pending trial on this case. I guess that's as succinct as I can put that.
Because the judge followed the statute?
Right. The statute is asking the court to hold my client against in violation of the state and federal constitution without bail.
Okay, but all right. So the statute lists a number of predicate offenses, among them the charges with which your client was charged, the crimes with which your client was charged. And you're saying that is it your argument that just simply by including the drug trafficking charges in that list of predicate offenses, that's a due process violation?
And I think that there's been my argument here around this drug offense. I think that the court could be a little bit more limited in terms of just all drug offenses always. It could never be constitutional. I think the way in which this statute, specifically the way in which it hooks the offenses, is with the 3-year range or above a 3-year minimum on the sentence for the offense. That's also part of the argument, that that's not narrowly tailored to a limited category offense. It's too overly broad and not considering factors that normally be considered when you talk about how dangerous something is. The simple sentencing scheme of the state isn't what determines whether or not something's violent or dangerous. And I use violent and dangerous intentionally together. I think that's a hand-in-hand consideration here. I think when you
so if a person in another case, and I realize that's not this case, if a person in another case had committed a drug offense with carrying a mandatory minimum of more than 3 years, and in the commission of that offense had used a firearm or otherwise used violence, let's just say used violence, you would agree that what would happen there under your argument?
Well, the specifics of the crime would really matter when you say violence. I mean, that could mean anything, but my answer to you there, I think, would be the crime of violence would be what would hook the 58A there. The additional addendum
but
there.
Just assume for a moment that he's not charged with any other crime. He's only charged with the drug offense in my hypothetical.
Strictly charged with the drug offense and no other crime of violence, then no, I would say the 58A should not apply. That's
unconstitutional. Okay, what's your best case for that?
So the best case for the menace of my best case for the nonviolent offenses shouldn't be
no for your answer to my question, which is even if a nonviolent offense is committed with violence, he's charged only with the drug offense, but he uses violence a person uses violence in connection with that drug offense. What's your best case that would say that is unconstitutional to hold him on a dangerousness finding?
So uncharged conduct that is taken in at the 58A hearing to be considered as part of the offense is that I would still be going with Mendoza and the other cases of menace of danger. But you're saying that the uncharged conduct being included as part of it, I don't have a case right in front of me to reference there, Judge. I think for me, I would just be applying more of the constitutionality of a due process clause with the consideration of uncharged, unconvicted conduct that also wouldn't be indicted either.
Okay, can the judge take into consideration the particular person's criminal history?
Yes, just like how they would in a bail argument, right?
Okay, so, and you're not arguing that the judge isn't supposed to look at those factors in determining whether or not to release a person
right.
pretrial, right?
Right. My focus really with this appeal is directly onto the kind of the first step of this test 50 day of the attaching the statute of whether or not you can even detain someone without bail. The other factors in the second step of that, where you're assessing the person's criminal history and things like that, is separate to really my point here with the challenge I'm making to the first analysis here.
Okay,
I'm
so
not
basically what you're saying is it should never be included as a predicate offense.
Right. The statute as designed with the 3 or more is not narrowly tailored. My client, I'm not sitting here saying he's just has a fundamental right to be released on his own causes no matter what. We may very well, if the court were to grant relief here, we may very well go down back to Superior Court and a bail is set. This would be a totally different situation than we're in today.
Okay, I think I understand your argument. Do you have anything else you want to add?
No, Judge. No.
Okay, I appreciate it.
Thank you.
Thank you for your argument. Attorney, I think it's O'Sullivan, correct? Or is it Sullivan?
Correct, Your Honor. It's O'Sullivan. Thank you.
Okay.
Good morning again. David O'Sullivan for the Commonwealth. I would just start with one point that was raised in Your Honor's question to my brother, and that is on the standard of review. As I understand my brother's claim, it is one that the legislature violated due process by including as a predicate for potential detention under 58A the class of 94C predicates that he qualifies for here. This court's review of whether the statute satisfies substantive due process is not an abuse of discretion standard. Rather, your review of that question is de novo, so it's more favorable to the defendant than my brother would suggest, I think. So he makes this
I think
claim.
that has to be right, actually. If his argument is as you've characterized it, which I think it actually is, then I agree.
And so he makes the claim under the substantive due process guarantees of the federal and state constitutions. And those provide that, or prevent rather, the government from engaging in conduct that shocks the conscience or interferes with liberties that are necessary to the concept of ordered liberty. And whereas here we have the pretrial liberty issue interest at stake, that's a fundamental right, and any interference with that right must be justified by a narrowly tailored scheme designed to serve a legitimate and compelling governmental interest. And so, as the court says in Mendoza, when it ruled on the constitutionality under the federal and state constitutions of 58A, the Commonwealth bears a heavy burden in justifying any interference with that right. And so normally I would say it's the Commonwealth's burden here to justify any such interference. And but the problem from the defendant's perspective is that Mendoza ruled that the statute with essentially the same provisions and the same class of 94C predicates met both procedural and substantive due process guarantees. Now, of course, over time, the class of offenses that fall within that class of 94C predicates has changed. In some senses, it has narrowed. In 2018, several offenses were kicked out of that class, and one of the offenses that the defendant that qualifies the defendant for potential pretrial detention was added. And so, as I think the court has made clear in MA, MA was of course the case that invalidated 58A's predecessor statute, and in Mendoza itself, which determined that that 58A satisfied our constitutional requirements, have made clear it's a question for the legislature what offenses qualify in the first instance that qualify a defendant for potential detention under the statute. That's just to open the door. And what the defendant does here is mirrors and echoes a claim that's been made before the SJC in the Vera case, which has been argued back in February, I think on February 10th, is not yet decided yet. But basically what they do there is they take some language in Mendoza and in MA and in Young, and they say, okay, what the observations they make concerning the predicate offenses are that they all involve a, quote, menace of dangerousness in Mendoza's phrase, or in Young, the observations they made was that all the predicates it involved a risk of harm to others or disregard of the safety or well-being of others.
Is there any legislative history that would shed light on the choice of the 3-year minimum term?
So as I mentioned, the short answer is that I'm not particularly aware of legislative history that goes directly to that predicate, Your Honor. But what I think is pertinent is that back in Mendoza, as I mentioned, the identical class of predicates was at issue or was in the statute at that time, and the court was reviewing a facial challenge under substantive due process to it, and they ruled it constitutional. And they were comparing it to the federal Bail Reform Act, and in that act, it had a class of drug predicates, but it was a different class. In that class, it was a 10-year mandatory minimum there. So arguably, under the federal statute, it was a higher sort of threshold. That's at the time they're comparing our statute to that statute, and they said nonetheless that the differences in the predicates that are designated under the Federal Bail Reform Act and those that are designated under 58A, there are differences there, and they are owing in large part to the differing roles that federal and state law enforcement have. I mean, we have.
In your view, what's the relationship between the first step of the analysis and the second step of the analysis?
Yeah, I think that's a critical question. The first step in the analysis merely opens the door, and that's the question of whether there's a designated offense under 58A.
All right. So from the Commonwealth's perspective, it's merely a predicate. In other words, and satisfaction of the predicate alone would not be enough to satisfy the judge's obligation or ultimate determination of whether or not to release a person on bail or not.
That's correct. And I think that was critical to the SJC's determination in Mendoza that the statute satisfied procedural and substantive due process analysis, because that just opens the door. Then there's an individualized determination on a relatively high burden of proof with protections for the defendant that are procedural and a requirement of written findings and the opportunity for review. All those things, narrow it, successively narrow it over the course of the progress of going through the statute. The first step is just one piece of the whole progression that the statute achieves, which as a whole achieves the narrow tailoring that's required. And this is a point I'd like to make with some emphasis, that when this court looks, or any court looks at a statute, it doesn't take one piece of the statute. It looks to the statute as a whole to determine whether it satisfies constitutional mandates. And here, the nature of the defendant's claim is to take one piece of the function of that statute, which is the initial designation of the predicates, and say, well, that in and of itself, it doesn't matter what else the statute provides for. And as Your Honor points out in your hypothetical to my brother, the fact that you could still be found not dangerous and routinely people in our county are found not dangerous after, the initial determination that yes, this is a predicate. So that's just one piece of the puzzle, and it's the court's obligation, I would suggest, to view the statute as a whole, and whether the statute as a whole amounts to governmental conduct that shocks the conscience. And I would suggest that it doesn't, and this is a narrowly tailored statute.
In your view, is there any reason, and then I'm sorry, because I'm going to come back and ask you the same question, Attorney DeMota, which I forgot to ask you. Is there any reason for me to hold decision on this until we see what the SJC does in Commonwealth versus Vega?
That's I think a great question, Your Honor, and I thought about that. And so it seems very likely that the court it will issue a decision in Vega that at least provides some guidance on this question, i.e., they're going to decide the question under 26910A, the carrying a firearm without a license offense, whether that is an offense that can be designated as a predicate consistent with substantive due process. So if that question informs this question, then yes, you're probably going to get some guidance in that. But I would suggest that there are differences with 10A and this offense here, I think, that are very plain. And whereas in Young, which is a residual clause case, and of course the residual clause was invalidated in 2019, but in Young, they do know that 10A is a regulatory offense. It could result from someone simply letting their valid license lapse through inattention. And in that sense, it doesn't involve any use of the firearm, any threatening people with the firearm, any menacing with people with the firearm. Here we have an undeniably dangerous substance, which you have to have a clear mens rea with respect to large amounts of this substance. And so I would suggest that those are differences that make a difference as between this statute and that statute. So yeah, the short answer is yes, Vera will likely provide some guidance on this question, but in
your view, it wouldn't be dispositive.
Yes.
Right. So I understand your argument. Is there anything you'd like to add at this point?
No, Your Honor.
Okay, so Attorney DeMota, do you have a position on whether you think I should hold this? I would assume that you would say no, because your client is in custody.
Right. I think that's something that I respect what opposing counsels mentioned here. I think that makes a lot of sense from a legal information standpoint as far as waiting for that decision. But my client is sitting in custody pre-trial while I'm waiting for the decision. So
I appreciate that.
Yeah. And that's something that I'm not sure how long they would be waiting for. We're waiting for the decision. I know when they made the argument in February, do they typically take about 4 to 6 months, or could it be who knows when?
Well, I don't actually answer questions, but
Sorry.
but they have a 130-day rule. So and they would certainly issue it before the end of the term. But I actually appreciate that your client's in custody, and that the decision in Vega, however informative it might be, would not be dispositive. It would probably be helpful, but not dispositive, because it's a different underlying offense. So with that, thank you both very much. And I'm going to take this under advisement.
Yes, Judge.
Thank you, Your Honor.
Thank you.
The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to this sitting of the single justice session of the Massachusetts Appeals Court. My name is Gabrielle Wolohojian. We're going to be hearing case number 2022J0261, the Community Builders, Inc. versus Orlan, Pena. And Attorney Treem, I'm ready for your argument whenever you are.
Thank you, Your Honor. Your Honor, I'm here today on behalf of Ms. Orlan Pena on her motion to stay the execution or levy of execution pending her underlying appeal of the Housing Court's order denying her motion to vacate the default judgment against her, and also her order denying the motion to reconsider their order denying the motion to remove the default. Although, Your Honor, you may review the standard or the stay de novo. However, the underlying appeal is being brought under an abuse of discretion standard, and where the standard for the stay is the likelihood of success of the merits of the underlying appeal, the likelihood of success of irreparable harm if the injunction is denied, and the risk of the irreparable harm to the moving party that outweighs any similar risk of harm to the opposing party. That standard of abuse of discretion is relevant to this proceeding as well. Your Honor, Ms. Pena is likely to succeed on her underlying appeal because Ms. Pena had good cause she met the standard to remove the default judgment against her under the Mass Rules of Civil Procedure 55C and also Rule 10C of the Uniform Summary Process Rules. Ms. Pena had good cause for not appearing at the Tier 1 mediation event on February 14th, 2022, as she did not receive the hearing notice of the date of the event.
So did the judge accept that explanation?
From what I understand, Your Honor, the judge didn't make any express findings as to why she denied
But we can infer that the judge did not accept the explanation for the non-appearance. Or assume that I'm going to think that I need to accept that the judge made those implied findings.
Your Honor, based on the defendant's other conduct, the defendant had submitted an affidavit as well, the defendant had credibly demonstrated through her persistent diligence after receiving the notice to quit leading up to the date of the default, that had she received the notice of the hearing, she would have appeared. So we believe that, under the circumstances, it is very likely that had she received the notice, she would have appeared and would have defended the case on the merits.
What is my standard of review for factual determinations such as that?
I'm not sure of that, Your Honor, but I'm happy to supplement that after the fact.
I don't think that'll be necessary, but ordinarily, wouldn't I be required to give some deference to the judge below's underlying factual determinations?
I agree, Your Honor. I can't be certain what the actual determinations were because there were no express written findings, and it doesn't appear that the Housing Court justice or judge made any express findings on the record before denying the motion.
Okay, so let's assume that the judge rejected your client's explanation for why she did not appear. What then? What remains of your argument?
Well, we believe that, Your Honor, that not only did Ms. Pena credibly testify that she did not receive the notice, but she also established meritorious defenses to the underlying eviction against her. Ms. Pena presented both substantive defenses to the eviction in her proposed answer, as well, which was also supplemented by an affidavit that she provided with the proposed answer, as well as an offer of proof that was filed with the Housing Court May 2nd, 2022, prior to the motion on the reconsideration hearing. The videos in the offer of proof were provided to us by plaintiff's counsel. And
how are those questions properly before me as single justice?
Because, Your Honor, the standard—
Wouldn't they be outcome determinative?
So for the standard to remove the default, Ms. Pena had to prove that she had good cause for not appearing at the tier 1 mediation, that she had meritorious defenses to the underlying eviction against her, and that there was no prejudice to
Right.
the
So she
landlord.
would have to show all three.
Yes.
All right. So as I said in my initial question, if I were, let's assume for the moment that I accept the implicit finding that she had no good cause for not showing up, right? Because it's undisputed that she didn't show up. What happens then? Because she will have not been able to satisfy all three because she won't have satisfied the first. I thought that one of the arguments you were making in your papers was that it's simply impermissible to default someone for failing to show up or failing to appear at a tier 1 event.
Yes, Your Honor. Sorry, that was part of my substantive argument on the meritorious defenses. It was a procedural defense, but yes.
Okay, so I'm curious about that, and I did a little research, and I found something that I don't believe, and I may be mistaken, that either of you cited, which is Trial Court Administrative Order 21-2. So I understand your argument to be that the and third amended standing order 6-20 of the housing court runs at odds with the summary process rules and the rules of civil procedure, and therefore it can't stand. A person can't be defaulted for failing to appear at a tier 1 event because standing order 6-20 is not consistent with the rules of the summary process rules or the civil procedure rules. That's what I understood your argument to be.
Yes, Your Honor.
All right. So then I came across this Trial Court Administrative Order 21-2, which suspends the inconsistent provisions of the uniform summary process rules.
Yes, Your Honor.
So can you tell me why that doesn't defeat your argument?
Of course,
to
Your Honor.
put it bluntly.
Of course. So when the original, when the Supreme Judicial Court did authorize the approval of the Trial Court Emergency Administrative Order 2013, that order specifically in the letter from Chief Justice of the Trial Court to Justice Graziano said that they were seeking the SJC's approval because they were looking to suspend certain uniform summary process rules, and that those rules are promulgated and approved by the Supreme Judicial Court. The SJC ultimately did approve the administrative order, and that order specifically led to the Standing Order 620, which specifically stated that tenants could not default at the Tier 1 phase. Subsequent to that, the first amended standing order, which was also under the Chief Administrative Order 2013, also held the proposition that you could not default tenants at the Tier 1 phase. Subsequent to that, the trial court issued the Order 2120, which rescinded the Trial Court Emergency Order 2013.
Right, 21-2, I think.
21-2, yes, I'm sorry.
Yeah.
And so it appears that the trial court, in their authority under Rule 5 has stated that they are suspending the rules, but where they have changed substantively what was presented to the Supreme Judicial Court under the first Trial Court Administrative Order, we believe that because the Supreme Judicial Court has not issued an approval of this subsequent trial order and the second and the third amended standing orders, which allow for the tenants to default at the Tier 1 mediation phase, which not only goes against the uniform summary process rules, but also against the rules of alternative dispute resolution by the SJC section 1118. So our argument would be that where the SJC did originally give the trial court explicit approval to suspend certain uniform summary process rules, it was based on that trial court administrative emergency order 2013.
Did the SJC say that it was limited to that?
So we don't have anything officially filed, but we did have somebody, one of our colleagues, check with the legal counsel of the Supreme Judicial Court's office to ask whether or not the SJC had issued any further approvals regarding the trial court rules since.
No, that wasn't my question. Sorry. My question was, did the SJC say, did it limit its approval to simply the first version of Standing Order 6-20? And then please just tell me what you're looking at so I can look at it too.
Of course, I was going to look at the order itself dated October 5th, which authorized the approval.
Okay, and what is the number of that order?
Apologies, Your Honor. That can be found in our addendum to our motion at page 36, Your Honor. It says that notice is hereby given that the Supreme Judicial Court has approved and promulgated rules as further indicated below, in that they have approved and promulgated suspension of certain provisions of Trial Court Rule 1, Uniform Summary Process Rules, as described in the attached letter from Chief Justice Carey dated October 1st, 2020. That letter specifically asked that the trial court allow the Trial Court Administrative Order 2013, and says that although the Supreme Judicial Court does not ordinarily approve trial court administrative orders.
Can I interrupt you for a second? Are you talking about your addendum or your appendix?
My addendum, I'm sorry.
I'm sorry, I don't see that.
It should be attached to our motion, I believe. I think I can also find it.
Oh, attached to your motion. I would have normally thought of something else. Okay, so let me just look. Is it page 36 of your addendum?
Yes, Your Honor.
Let me just look. You don't need to read it to me. I can just. Okay. And I guess you're taking, your argument is that that approval did not allow the trial court to subsequently make further amendments?
The trial court in the standing orders did leave a provision for themselves that they could make amendments, but our argument is that if they were going to substantively change what had been previously authorized by the Supreme Judicial Court, and if the change was going to further disrupt the Uniform Summary Process rules or go against what they state, that they should have sought additional approval from the Supreme Judicial Court before amending the.
Okay, I see. And then what about General Laws, Chapter 211B, Section 9? Because that is what the Chief Justice of the trial court
2
cited.
minutes.
Thank you. That is what the Chief Justice of the trial court cited as her authority for continuing to suspend the provisions of the summary process rules.
We don't argue that the administrative justice of the trial court does not have the authority to amend under the statute. We believe, however, that where the Supreme Judicial Court officially authorized the previous trial court administrative order, that if they were to then change what had previously been approved by the SJC, meaning that the tenants were now allowed to default at the Tier 1 mediation phase further approval from the Supreme Judicial Court was required to do so. So although they could make the amendments, in Spence v. Reader, Your Honor, the court held that the rules of court are the force of law, and that if that an emergency order procedures regarding eviction cases cannot contradict the summary process rules. And so in Reader, the Supreme Judicial Court invalidated certain emergency procedures that the housing court had created for certain eviction cases.
What was the year of that decision?
1981, Your Honor.
Right. So that's not in the context of the pandemic, which so many things were changed during the pandemic. I guess what I'm struggling with right now is your argument would in essence mean that if I were to accept it, that the Supreme Judicial Court its approval somehow narrows the scope of authority that was conferred by statute on the Chief Justice of the trial court.
I think that based on the letter provided where the court specifically sought SJC approval for these standing orders, I think it could be argued that because the trial court rules are subject to the SJC approval, the trial courts are allowed to create standing orders and amend those standing orders. However, where they do conflict with the current rules of the trial or the rules promulgated by the Supreme Judicial Court, it would be under the authority of the Supreme Judicial Court to further authorize any amendments that would continue to change those rules.
All right. I think I understand your argument. Thank you. Attorney Downing?
Yes, Your Honor. I just want to briefly touch on some of your questions you were asking. We believe the standard with regard to the motion to vacate and also the motion for reconsideration is she's got to make some showing of an abuse of discretion. And we don't think in this case, Your Honor, you have any arbitrary determination, any capricious disposition, whimsical thinking, or idiosyncratic choice. I'm quoting from Greenleaf, which is cited in my brief. Your Honor, the court did have
That's not the current formulation of abusive discretion.
I understand, Your Honor. I'm sorry, I apologize.
Yeah, I mean, I think we're all using the standard from LL.
Mm-hmm. But again, Your Honor, what you have is the trial court judge had the ability at the hearing on the motion to vacate the default judgment to judge the defendant's credibility. Should the defendant testified at that hearing? She also had introduced documents, including a document in which she admitted to some of the actions that are listed in our notice to quit, Your Honor. The judge had the opportunity to review it to determine her credibility, and there's nothing that they have shown that would show that the judge somehow didn't do that correctly, Your Honor. So again, whether or not the judge made specific findings, it's clear that she found that she did not meet the two standards. I think, however, Your Honor, the court wants to more focus on the second issue, was dealing with the standing order. And in fact, Your Honor, I did in my brief cite to the administrative judge, the Chief Justice's the order 21-2, Your Honor, because I believe that what that did is, number one, it acknowledged that there had been a Second Amendment and a Third Amendment to the standing order 6-20, which in itself took place of another standing order 5-20. So there's been a series of orders issued by the Chief Justice of the Housing Court. And in each of those orders, Your Honor, it specifically states that these orders may be modified or rescinded based upon the fluctuating circumstances of the pandemic. And in fact, the court has done it. What is ironic, Your Honor, is that what the court has done by the Second and Third Amendment is actually placed the court process back closer to what the rules had, which was at the initial event, if either party didn't show up, either a default if it was a defendant or a dismissal if it was the plaintiff didn't show up. What it did was take it back more towards what the Uniform Summary Process rules. What the standing orders did, however, Your Honor, is actually extend the time, because these standing orders, Your Honor, the tenant would have approximately a week and a half between the time that they got the summary process complaint and the initial event. And in the summary process complaint, it would tell them what the initial event is. In this case, Your Honor, the defendant was served with the summary process complaint in December. The court sent out a notice January 6th, notifying her that in about 6 more weeks, there was going to be that initial event, and telling her that if you don't show up, you could be defaulted. It says actually to both parties, if either party doesn't show up, they could be defaulted or dismissed. So in effect, what the Second and Third Amendment is to begin to return some of the process back to what was in the Uniform Summary Process Rule. But despite that, Your Honor, the administrative office came out on that rule and said, okay, if there's a conflict, then that part of the rule is going to be suspended. My sister has not put any information that would show somehow that the Supreme Judicial Court has some sort of requirement that they keep approving these orders, Your Honor. And again, if you are—
But I mean, would you at least agree in theory that there might be, that authority may not be infinite? Let's say that the housing court decided to impose the death penalty in the standing order. Presumably, that would go beyond the scope of the SJC's authority to promulgate standing orders. So how would you articulate where the outer edge is?
The standing orders, as far as I can see, they don't get rid of any of the rights of either party under the summary process rule. What they do is expand the time in which to exercise those rights. For example, under the summary process rule, the defendant is required to file an answer at least 3 days prior to the trial date. And now what happens is the defendant is required to file that answer 3 days before that initial date, which is the Housing Specialist Status Conference. Okay, so that gives, in this case, the defendant an additional 5 weeks to file that answer.
I don't think the argument is that the standing order is to be compared to the summary process rules. I think the argument is that at the time the SJC approved the suspension of the summary process rules in favor of temporary standing orders, and in this case, it would be the first version of Standing Order 6-20, you couldn't be defaulted, a tenant couldn't be defaulted for missing a Tier 1 event. And that the subsequent amendment of that standing order was important enough and significant enough that it should have gone back to the SJC before it was implemented. I think that's the argument. So it's not really comparing it to the summary process rules. It's comparing it only to the first version of the standing order.
Again, Your Honor, that initial Tier 1 event from the beginning, even back to 5-20, the original standing order under the pandemic, that was never meant only as some sort of mediation. My sister mischaracterized that. If you read it, it is a status conference. It is to determine where the parties are. And what
I did read it, but it also says default shall not enter at the first tier.
Right, that's in the original. And I agree with that, Your Honor. That's what 5-20 and the original of 6-20 is. But again, the purpose of that hearing never was just to mediate the case. So the court made a determination that that was going to be treated as the equivalent of the initial event in the pre-pandemic time, which is why you could come up with the default. And again, Your Honor, I would have a little bit more sympathy if what you were talking about is they narrowed down the time within which to, the defendant is notified of these things. But instead, they left the time frame much larger than it was before. So again, there is much more of a ability to understand the consequences of failing to appear at that initial event. And again, Your Honor, you still have that the 21-2, which talks about, well, okay, if there's a conflict here, we're going to do it. So even if somehow this knocks out the Second Amendment, it doesn't knock out the Third Amendment, because again, that's what both 211 Section 10, 211B Section 10 allows them to do. They are allowed to adjust their procedure.
Section 10 or section 9?
I believe it's section 10, but if the court believes it's section 9, I will.
No,
happily follow.
I want to see, because in trial court administrative order 21-2, it cites chapter 211B section 9. So I just want to make sure.
I will accept my correction, Your Honor.
No, I mean, oftentimes, more often than you'd know, the online version of various things has typos in it. So I may be heading in the wrong direction. I'll check that out. I'm just going to make a note that
I know that
you're thinking it's section 10.
Yeah, I believe rule 5 of the trial court, which is the one that talks about the adoption of standing orders, Your Honor, is under 211B section 10. But again, it might be that the 21-2 was issued under section 9, because 211B section 10 talks about the authority of the trial court. So the power of the chief justices, I believe,
Is in section 9.
Okay. Thank you, Your Honor. So part of what we're looking at is, Your Honor, you have a court that has the authority to adopt standing orders, adopted a standing order in the unique circumstances of the pandemic. The cases that my sister talks about, as the court has noted, all predate this. There's a lot of things that have been changed since the pandemic, Your Honor. We've all experienced it. I would say that in this case, Your Honor, this is not an argument that has sufficient heft to be able to have, again, a determination. And I went through, Your Honor, and I gave the cases that I was able to find in terms of, I've not yet found a case, and it may be because of the circumstances of the case, that talks about the standard of review when you have a appeal on a motion to vacate and a motion to reconsider, where there's been in a summary process case. It's not there. The nearest I got to it is I found the 2 criminal cases that lead me back to the civil case that talk about it as far as what you do in terms of a stay, Your Honor. I would suggest that this argument that they have, while I understand they're trying to put it forward, I don't really think it is an issue that has sufficient heft to it that the appeals court should be taking it up. Because again, part of what they're saying is, well, we don't like this one provision. There's other provisions that we're okay with, but you can't have it one or the other. As far as I'm concerned, Your Honor, if they're saying that the Second and Third Amendment to the Standing Order 6-20 is bad, then it's all bad. So in other words, the court's procedure that it's been following since October is all bad. And I don't necessarily think that's what the case is in this kind of situation, Your Honor. I was not able to find anywhere where it says the Supreme Judicial Court has to, every single time a standing order is changed, has to have some kind of approval to it. And I don't think she even cited to that. I think they just said it and then moved on to a different topic, Your Honor.
Do you think my standard here is just the ordinary standard for rules, MRAP 6 motions for stay?
Yes, Your Honor.
That's what I think. So she doesn't, the tenant does not have to prove that they would prevail on the issue that they're going to appeal. They just have to present a meritorious issue on appeal.
And
which
that's what
Commonwealth versus Nash, as I read it, is a fairly low bar. So I won't be able to quote it perfectly, but it's something like, it presents an issue that would provoke an appellate discussion, a dialectical appellate discussion on both sides of the issue.
It has to have one appellate issue of sufficient heft that would give an appellate court pause. And the question is the only issue that I see that theoretically could do that is this issue about the standing order, but I don't think it does, Your Honor, because again, what you have is a court that went through the proper procedure, got the approval from the administrative office, and yet they're saying, well, they can't do that. And again, there's no case law that they have that supports that. The only case law they rely on are all things pre-pandemic, Your Honor. And it's what's there, in effect, they're trying to say is the court cannot, again, modulate the timing of things, because they're not getting rid of any rights. That's the important part about it. Every right that's in the summary process rule has been preserved. The only change has been to the timing of those rights. And in fact, what it has done is given the tenants more time to do things that they're supposed to do than less time. And I would say, Your Honor, that's not the thing that the court should be encouraging, to say to the court, you can't have more time to the defendants to do what you need to do.
I understand. Your
2
time
minutes.
is all right. Is there anything else you'd like to add?
No, Your Honor. The rest of it's in our brief, Your Honor.
Okay. Thank you. It's a very interesting case, and I'm going to take it under advisement. Thank you both for your
Thank you, Your Honor.
able and informative arguments. And with that, the case is submitted.
Thank you, Your Honor.
Your Honor.